best ways. I mean, so under the statute, there are certain cost items that an association would pay for a vendor, and if they exceed a certain percentage of the budget, depending on if it's an HOA or a condo, it's 10% for an HOA, 5% for a condo of the total budget. If it exceeds that amount, then there has to be a written contract with the vendor. If it's less than that, there doesn't have to be. But I always advise if somebody is going to be doing work that could expose the association to some kind of liability, whether it's through personal injury or through property damage, to have a written contract. So in that written contract with the vendor, you can have what's called an indemnification clause, which basically says if anybody gets hurt because of the vendor's action and they sue the association, and the association can come after the vendor to indemnify them for any damages that a judge or jury may award to a person that's injured or that suffers property damage based upon the negligence or some other tort that was caused by the vendor. The other thing is, on bigger projects, what I advise associations to do as well is to make sure that not only does the vendor have sufficient insurance to cover an issue if the association is sued, but also to add the association as an additional insured, kind of a rider on the insurance policy that the vendor would have, so that it's clear that the association is covered by the vendor's insurance on top of any insurance that the association may have, so that they don't have to pay extra money, legal fees, deductibles, things of that nature, if it in fact, and just ultimately the amount of coverage, if it exceeds what the association has. The vendor's insurance company should foot the bill for all those if the vendor was at fault. But one of the ways that the association can further protect themselves is to actually be listed on that vendor's policy for whatever time frame that the vendor is going to be involved in doing work there, and possibly beyond if something happens because of the vendor's negligence, and you have an injury after the vendor has left, but obviously it's the vendor's fault, then that being added to that policy should, depending on whether or not it's the rider is written properly, should protect the association with the vendor's insurance.